Hello, my name is Ian Dutton. I'm the editor of the South African Medico Legal Reports. And today we have our very first training session for the current awareness for legal representatives. We've got a great case for you, and I'll take you through exactly why I chose this case in a moment. All right, the case in question is Stone versus IVANISEVIC and another. It's reported in the South African Medico Legal Reports under our unreported judgments for the moment. We'll see whether this case actually finds it into the South African Medico Legal Reports proper, but for the moment you'll find it on our website. Let's just start off with, why is this case important? You know, this is actually a really good case to get started with, because there are three important key points in the case, and they relate to three important areas. So firstly, there's an important principle dealt with in this case regarding the analysis of facts, in particular how the court approaches disputes of fact. So firstly, that's something that comes up often when the court grapples with questions of fact. Then secondly, important principle regarding the law, particularly for lawyers practicing in delict, and that's personal injury lawyers. For those of you that aren't lawyers, to understand delict, it's basically a civil wrong. So it's not a criminal case. It also doesn't arise out of contract. It arises out of more or less the everyday activity between human beings, if you like. So, for instance, a motor vehicle accident is a form of delict. It's a big category of law that we use. Another example, as you will see in this case, is if somebody assaults somebody else, it could lead to criminal charges, but it could also lead to them being sued in court for damages, in other words, for payment. And that then falls under the law of delict. So that's the important principle related to the law of delict, is the principle of what is often most commonly referred to as wrongfulness. But I actually prefer the alternative phrase, which is unlawfulness. And we'll get into why I prefer that. I think it's more accurate and sort of easier to understand. But this concept of wrongfulness or unlawfulness is central to every case brought in delict. It's often not expressly dealt with in personal injury cases. There are various reasons for that, mainly because it's usually assumed that if there's a personal injury or physical injury, there's a presumption that the conduct was unlawful. But the question of wrongfulness or unlawfulness is central to the structure of a case in delict. And this case zeroes in on the question of wrongfulness or unlawfulness and discusses it, and we will have a look at that. And then thirdly, it's a case that is relevant to school sports. There have been a number of authorities recently relating to the duties which schools have to take care of participants in sports events on their fields. So that's why the case is important. Let's just have a look at what we'll go through in this video. This video accompanies the training material on the South African Medico Legal Reports website. If you're watching this video alone, there is ancillary material, including reading material and video material relating to a number of aspects of the case which are important. So please get access to that training material as well. You can watch this video on its own. It'll be informative if you've managed to access it through some other way of us disseminating it. But let's firstly have a look at the introduction. Then we'll look at the facts of the case. Then importantly, we'll look at the court's approach to disputes of fact. As I mentioned a moment before, how does the court grapple with that? Then we'll look in this case at the findings on the facts which the court came to. We will look at questions of credibility and reliability. Then we'll look at probabilities, how the court approaches the question of probabilities and uses that to decide which version to prefer. There's reference to private defense or putative private defense. Then a decision not to prosecute, the relevance of extracurrial sanction, and then the case which was brought against Bishops. You'll see in a moment, Bishops was second defendant. What happens when new material is raised against a defendant for the first time at the hearing? The test for the case against Bishops. This relates to what I said earlier about cases brought against schools. Then we get to wrongfulness. We will look at the concept of reasonableness. Now, the lawyers will know that reasonableness can relate to negligence, but not every lawyer knows that reasonableness also underpins wrongfulness. We'll look at that concept and why it is that reasonableness is important in assessing wrongfulness / unlawfulness as well as negligence. And then we'll have a look at the duty of the school, the finding which the court came to, and then the order which the court made. All right, let's start. This was a delictual claim for damages, in which, so in other words, arising from the law of delict, claiming damages, in other words, there's going to be financial payment, in which the plaintiff sought to hold the defendants jointly and severally liable for payment of just over 645,000 rands, plus interest and costs. The claim arose from an incident which occurred on the 3rd of February 2018 during an under-19A water polo fixture between Rondebosch Boys High School, Rondebosch, and the second defendant, which was Bishops. So Bishops was sued in this case as second defendant. At the school premises of Bishops, that's going to become important when we have a look at the duty which the school has. The Bishops were the host school. That attracted certain legal obligations, as we will see. By agreement, merits, I'm sure everybody's familiar with the loose concept merits, often referred to as liability. One has to be careful of this language. The recent authorities where the courts have cautioned against the loose use of the word merits, liability, and quantum, but we won't get into that in this video, but just to make that note. But for present purposes, where merits was separated from quantum, and the trial proceeded at this stage on the question of the merits only, with quantum to be determined at a later stage if necessary. Let's have a look at the facts of the case. The plaintiff, we will refer to as Ross, was participating in the match for Rondebosch, and the first defendant, named Bingo, for Bishops. The court made the point, and I'll just echo that point here, that their first names are used without any disrespect, but for the sake of convenience, as occurred during the trial, and as also was referred to in the judgment, so it's convenient to use their first names. Both were grade 12 learners at the time. During the last chukker of the match, Bingo punched Ross. It is not disputed for purposes of the merits determination that he did so with his fist, causing injuries to Ross's face, teeth, and jaw. And if you go and have a look at one of the related videos, which I'll put up on the training material, you'll see how extensive those injuries actually were. It wasn't just a light punch, and you'll see the court makes that finding, in fact. But I think it's worth having a look at that image of the injuries that were actually inflicted to get a proper understanding of the case. You can also have a look at the accompanying video, which deals with, it's an interview with Ross Stone, who is the plaintiff in this case, and it shows him competing in water polo and gives you an idea of how water polo is conducted, the sort of strength of the players, very physically fit and capable players, and a full-strength punch from one of those players can inflict a tremendous amount of damage. It is common cause that Bingo immediately received a red card for brutality, and the match was drawn to an early close. Thereafter, in accordance with Bishop's school rules, disciplinary procedures and codes of conduct, Bingo was called to a disciplinary meeting at which he was found by Bishops to breach the school rules and sanctioned inter alia to a 7-month ban. So he received a ban, he received punishment from the school, but you'll see later, if you read the judgment, the court held that is irrelevant. It does not extinguish the claim, and one continues to assess the claim in the civil courts. Let's have a look at Ross's version of events. Ross testified that the match was in its final chukker, and the score was tied at that stage. Ross had already scored 5 goals for Rondebosch. The Rondebosch team was on defence. Ross intercepted and secured the ball, going on attack towards the goals with the ball in front of him, pursued inter alia by Bingo on his left. Bingo swam across Ross's back as he advanced towards the goal, causing Ross to be pushed underwater for what he described as about 3 to 4 seconds. His evidence was that, there's a quotation, obviously being underwater, I did not have a clue about what was going on, other than I knew I could not really get up as someone was on top of me. I then came out from underwater and obviously gasping for air. My mouth was open, and as I reached the surface, I received a swinging arm from out the water that connected with my mouth above the water. That was Ross's version of events. Ross, in cross-examination, was referred to Bingo's plea of private or self-defense, in which it was alleged that A, Bingo had been instructed by his coach to defend against Ross. B, at a point when Bingo was defending to prevent Ross from scoring a goal, a scuffle ensued during which Ross grabbed Bingo's cap by its drawstrings, pulled him underwater, and continued to assault him by punching, kicking and or kneeing Bingo in his face, stomach and genitalia. C, the force inflicted by Ross's attack to Bingo's stomach forced the air from his lungs, causing him to take in water. And D, believing himself to be drowning, Bingo swung a reactive punch in self-defense in the direction of Ross, which connected with his mouth at the moment the pair breached the water. Okay, so that was Ross's version and Bingo's version. Just before we turn to examine the facts and how the court dealt with that, for purposes of the merits determination, it was not in dispute that as a result of the punch, Ross suffered a fracture of the alveolar margin of the maxilla and the displacement of numerous teeth, as well as a dislodged tooth for which he was required to undergo dental surgery, including a bone graft socket preservation for one of his teeth. The court found that the punch must have been given with considerable force. And if you do look at those images, you'll see that goes almost without, certainly seems to be borne out by the images. Regarding Ross's case against Bingo, there were therefore two diametrically opposed versions of the incident itself. So you've got the version by Ross and the version by Bingo. Effectively, Ross saying that Bingo assaulted him for no apparent reason, other than potentially to prevent him from scoring a goal, but certainly not as a result of an assault. And Bingo saying that he was first attacked by Ross and then he acted in self-defense. So you've got two different versions. Ross bore the onus of establishing on a balance of probabilities that Bingo caused the incident resulting in the punch, and that in punching him, Bingo was negligent. Now let's have a look. How does the court then deal with these disputes of fact? And what the court did, now, for the practicing advocates and attorneys, legal representatives, we deal with disputes of fact regularly. It's actually worth recapping on the properly structured approach which the court should take. It helps in preparation for disputes of fact. It helps in leading the witness. It also particularly helps with cross-examination and directing cross-examination towards a particular argument on the facts, if one bears in mind these little categories as one prepares cross-examination and then argument following on from that. Anyway, the court applied the well-established approach to determining a dispute of fact set out in SFW Group Limited and Another versus Martel et Key, 2003 decision. To come to a conclusion on the disputed issues, a court must make findings on A, the credibility of the various factual witnesses, B, their reliability, and C, the probabilities. Incidentally, the citations are available on the website. On the judgment itself is available on the website. Those citations can be found there. As to A, the court's finding on the credibility of a particular witness will depend on its impression about the veracity of the witness. That in turn will depend on a variety of subsidiary factors, not necessarily in order of importance, such as 1, the witness's candor and demeanor in the witness box. That demeanor is important. Candor, honesty, frankness is important. It creates an impression on the judge. 2, his bias, latent and blatant. And it's interesting regarding latent bias, there are recent judgments where the courts say that it's regrettable, and you'll see if you get the quantum guidelines, one of the leading cases on assessing expert witness evidence, it talks about latent bias. Internal contradictions in his evidence, and then external contradictions with what was pleaded or put on his behalf, or with established fact, or with his own extracurrial statements or actions. 5, the probability or improbability of particular aspects of his version. 6, the caliber and cogency of his or her performance compared to that of other witnesses testifying about the same incident or events. So there's a nice handy checklist of factors. I'm not going to discuss them in any detail. Those that practice in the courts will be familiar with that type of concept, but it's very nice to have that useful case list from that point of view. Now, as to B, a witness's reliability will depend, apart from the factors mentioned under A, 2, 4, and 5 above, on 1, the opportunities he had to experience or observe the event in question, and 2, the quality, integrity, and independence of his recall thereof. So his ability to observe and then his ability to remember that and to recall that. How accurate is it? That can all be tested. As to C, this necessitates an analysis and evaluation of the probability or improbability of each party's version on each of the disputed issues. In the light of its assessment of A, B, and C, the court will then, as a final step, determine whether the party burdened with the onus of proof has succeeded in discharging it. The hard case, which will doubtless be the rare one, occurs when a court's credibility findings compel it in one direction and its evaluation of the general principles in the other. The more convincing the former, the less convincing will be the latter. The court then says, but when all factors are equipoised, probabilities prevail. I find that an interesting comment, that the probabilities can outweigh credibility. I'm not entirely sure that I'm in agreement with that comment. For those experienced practitioners, if a witness is credible, even though the version might be unlikely or improbable, does that credibility not outweigh the probabilities? Anyway, just a thought for those who are experienced in cross-examining. Now, just insofar as this case is concerned, the court found that Ross was a good witness who was consistent in his version, did not attempt to embellish it, and was candid when he was unable to cast light on any particular aspect. The clear impression I gained, this is from the court, is that he was an honest, credible, and reliable witness. Regrettably, the same could not be said of Bingo. The court found him to be an evasive witness who went to considerable lengths to distance himself from taking responsibility and moreover demonstrated a propensity for economy with the truth. The court then held that on the issue of credibility alone, where the two versions differed, the court had no hesitation in accepting Ross's version and rejecting that of Bingo. Now, so that then effectively established the case against Bingo. It was a straightforward dispute of fact. But now in respect of the case against Bishops, the court held that Ross had to prove on a balance of probabilities that Bishops breached its legal duty towards him, and here's interesting, to take all reasonable steps to ensure his safety and well-being while playing water polo against Bingo. There's your test. Did Bishops take all reasonable steps to ensure Ross's safety and well-being while playing water polo against Bingo? Not every conceivable step, just reasonable steps. Then the court goes on to talk about the test for wrongfulness is an objective one. The question whether a legal duty has been breached is determined with reference to the boni mores or general legal convictions of the community. And what the court was saying here is that when you consider whether the actions by Bishops was wrongful, you have to you are in fact conducting an exercise in what are the legal convictions of the community as to whether the steps taken by Bishops or steps that weren't taken by Bishops, in other words, Bishops' conduct, whether that was such that the legal convictions of the community demanded that they be delictually liable, in other words, liable in civil law. Then turning to H versus Fetal Assessment Center, the Constitutional Court articulated the point of departure when determining wrongfulness. Very interesting quote this. In addition to the general normative framework of constitutional values and fundamental rights, which of course underpins all of our law has developed an explicitly normative approach to determining the wrongfulness element in our law of delict. It allows courts to question the reasonableness of imposing liability, even on an assumption that all the other elements of delictual liability, that's harm, causative negligence, and damages. So harm, that there was an injury suffered, causation was present, the conduct was not reasonable, and the damages were suffered. Even if you have all of that, you still need to establish that in the circumstances of the case, it is reasonable to impose a liability in the circumstances of that case. All of that must have been met on grounds rooted in the Constitution, policy, and the legal convictions of the community. So, in other words, I tend to think of wrongfulness, and this is why I like to call it unlawfulness, because that is, to me, the boundary line between conduct which is lawful, you cross that boundary line, and now the conduct is unlawful, and you can therefore be sued on it, provided all your other elements are there: harm, causative negligence, and damages. In other words, within that boundary is your unlawful conduct. Outside that boundary, doesn't matter whether you were negligent, doesn't matter whether you caused harm, Doesn't matter whether damages were suffered. If it's outside those boundaries, then there is no delictual action. There's no cause of action. And what that means is that where's the dividing line? And the court here sets it out. Is it reasonable to impose liability in the circumstances of the case? Let's have a look at this concept of reasonableness in respect of wrongfulness and unlawfulness. The nature of reasonableness in the wrongfulness inquiry should not be confused with the nature of reasonableness in the negligence inquiries. It can be a little confusing at first. Here you've got one notion, reasonableness, applied to two important elements, wrongfulness or unlawfulness and negligence. In the wrongfulness context, in other words, is this conduct unlawful? Can you be sued if you prove all those other elements, including negligence, causation, damages? Is this conduct unlawful? That's why I prefer to call it unlawfulness. I think it's a more accurate descriptor. But anyway, in the wrongfulness context, the issue is whether it is reasonable to impose liability in the circumstances, having regard to the legal convictions of the community. What does the community make of this conduct? Should it be unlawful or not? In this case, is a very good example of where conduct, even if all the other elements are present, is not unlawful. It is about whether or not an independent bystander, taking into consideration all aspects of the case, would consider it appropriate that liability ensue. Is it appropriate that you could be sued for this conduct? On the other hand, reasonableness in the negligence inquiry, although still objectively assessed, contains a more subjective aspect in that it looks at the situation through the eyes of the defendant only and does not attempt to balance that perspective with the interests of the plaintiff and those of society generally. The inquiry focuses on the blameworthiness of the actor's conduct, taking into account whether a reasonable person in the position of the defendant at the time would have foreseen the possibility of the harm occurring and would have taken steps to prevent that harm from occurring. In other words, was the defendant's conduct negligent and therefore deserving of sanction? It wasn't an acceptable standard of conduct. But we get that a lot within personal injury work, particularly medical malpractice work, where the standard is elevated to the standard of the reasonable practitioner. Has the person in his or her conduct, whether through what they did or for what they failed to do, complied with a reasonable standard of conduct? That is the negligence inquiry. The wrongfulness inquiry is different. The wrongfulness inquiry is assuming that this person acted negligently and assuming this person caused harm. Is this type of conduct the type of conduct where we should impose legal liability? So that is where the legal convictions of the community will determine the answer to that question. Let's have a look now at school sports to illustrate those theoretical concepts. As the point of departure in the inquiry into wrongfulness, water polo and other contact sports like rugby are played throughout South Africa at a schoolboy level, and it is thus regarded as reasonable to permit such sports according to the legal convictions of the community. In other words, it's not unlawful or wrongful to allow those sports to occur, even though they are contact sports and even though they are sometimes rough. It's not unlawful to allow that. Why not? Because of the legal convictions of the community. Then the court went on to say, the punch took place during a contact sport, which is by its nature physically aggressive and robust. In other words, we will allow those sports. The legal convictions of the community are, we should allow those sports. Conduct that results in red cards is undoubtedly misconduct and not acceptable, but it is nevertheless foreseen as a risk when participating in a contact sport, as Ross accepted. In other words, he accepted the risk of a red card offence. If it were not, the governing organisation's rules would not specifically mention red cards and provide for a range of sanctions for such behaviour. This is not an excuse for the behaviour. It is merely relevant to the question of its foreseeability as a risk when participating in a contact sport, and the schools nevertheless permit them to be played. In other words, as I understand what the court was saying here, is that this goes to the legal convictions of the community. Because it's foreseeable that conduct on the sports field might even include red cards, conduct worthy of a red card. That doesn't mean that the school should be sanctioned for its conduct. without more. You have to examine the school's conduct more closely. You can't just say that because there was a red card, the school is liable. Ross did not adduce any evidence of Bingo's behavior during the match up until the incident, which would have alerted bishops, the referees, or anyone else that the incident was going to occur, or that any steps should be taken to prevent it from occurring. In particular, there was no evidence that Bingo was, prior to the incident, evidencing an aggressive sporting display, and that Bishops was allowing or condoning it. Accordingly, cut to its bare bones, Ross's case was ultimately limited to whether or not, in light of a previous alleged poor sporting disciplinary record of which Bishops was or should reasonably have been aware, Bishops should not have played Bingo in the match. The evidence demonstrated that at the time of the incident there was no sporting disciplinary records for Bingo held by either Rondebosch or Bishops. Put differently, he had a clean sports disciplinary record at both schools. In summary, what the court found is that this was not a situation where Bingo was acting aggressively and out of the norms of that particular sport to the point that the referees or the school or the governing organization should have stopped the match. There was no such evidence led. Had that been the case, the outcome may very well have been different. Also, therefore, what happened is that the case turned on whether there was a poor disciplinary record on the part of Bingo. The court found that there was no such evidence. And the court accordingly ordered that the plaintiff's claim against the first defendant succeeded because he'd punched Ross, according to Ross's version, out of the water in an unprovoked way, and dismissed the plaintiff's claim against the second defendant with certain ancillary relief we don't have to worry about here. Okay, then just to summarize, so this case demonstrates very nicely how disputes of fact are dealt with, which come up regularly. It's a nice little checklist of what one considers when looking at disputes of fact. And it also demonstrates nicely this concept of wrongfulness and unlawfulness and how it dovetails, to a certain extent, how it dovetails with negligence. I will put some in the next few weeks. I will look out for a case where I can take a little bit of a deeper dive into the question of reasonableness in negligence. There's a very good article by Fagan which deals with this particular question. A lot of the court's thinking around this area comes from that article. May well, even depending on whether the opportunity comes up, might be worth looking at that article to understand these concepts. Thank you very much. I hope you enjoyed that case. We will be having a look during the course of this week at a number of other very interesting cases. Please have a look at the materials that accompany this case. It's very informative. And the entire judgment is available with the training material. I'll put that up with the training materials. And it is also available on the website. Have a look at that material. And then on the Friday of every week, we will then make the questionnaires and assessment available for the week. And then by the end of the month, you will then, if you complete the questionnaire satisfactorily, you will be entitled to a certificate establishing your proficiency in medico-legal work. That'll be particularly useful if you want to put that on social media, you want to put it on your CV, job interviews, if you're applying for a job interview, if you're an advocate, to show your proficiency in current awareness of medico-legal matters. Thank you very much. We will meet again in the next video.